You know, the College of Charleston, our sister school right around the corner, never gets tired of bragging that it was founded by 3 men who signed the Declaration of Independence and 3 other men who were authors of the first Constitution. In other words, they say the College of Charleston was founded by the founding fathers of the country. In a very real sense, we are honored today with yet another founding father. Abe Krash did not, of course, write the Constitution. He's not that old. But when he worked hand in glove with Abe Fortas to represent Clarence Earl Gideon and give us Gideon versus Wainwright, he accomplished something just as important. Prior to Gideon, the vast majority of criminal defendants were not represented by a lawyer. For them, the Bill of Rights, as promulgated by the Founding Fathers, was often meaningless. Without Gideon, justice was altogether a sometime thing in America. Without Abe Krash, there would have been no Gideon. Thanks to him, constitutional rights became meaningful in America. The Charleston School of Law has had many distinguished visitors in its relatively short life. Important lawyers and judges, including our own Chief Justice who's with us today, William Hubbard, who is also with us, President-elect of the ABA, members of the United States Supreme Court as well, even the Chief Justice. But with all due respect, we never had a more important person as Abe Krash, who honors us with his presence, a more important person to America. He received a law degree from the University of Chicago in 1949 and was a graduate fellow at the Yale Law School. He's been a visiting lecturer at the Yale Law School and is presently a visiting professor at the Georgetown University Law Center, where he teaches constitutional law. He's an author of numerous articles on topics from constitutional law to trade regulations, criminal law, federal procedure. He was for many years head of the Arnold and Porter Antitrust Practice Group. He was president of the Friends of the Law Library of Congress. He was counsel to major corporations, including, among others, Miller Brewing Company, Kraft General Foods, Philip Morris, Lever Brothers, and Monsanto. But more importantly for our purposes today, he was counsel to Clarence Earl Gideon. I give you our guest, Abe Krash, Esquire.
Thank you, Judge Sanders, for your extremely generous and lovely introduction. The lavish introduction prompts me to recall a custom that existed in ancient Rome. Victorious generals returning from the provinces were accorded a triumphant parade through the streets of Rome, and they rode in a chariot drawn by horses through the streets, which were lined by crowds of people waving to them, shouting. And by custom and by law in Rome, a citizen was placed in the chariot standing in back of the victorious general. And he was directed to whisper in the general's ear as they rode through the streets every few minutes. He leaned forward, the citizen leaned forward and said to the general, "Remember, you are mortal. Remember, you are mortal." I want to thank the sponsors for inviting me to participate in this splendid symposium on the right to counsel for indigent defendants. I've been privileged during the past year to participate in a number of events commemorating the 50th anniversary of the Supreme Court's decision in Gideon against Wainwright. It was decided in March of 1963. I want to say that, measured in terms of the thoughtfulness of the observation, the perceptiveness of the remarks by the various panelists this morning, I regard this as one of the finest symposiums that I have attended, and I'm privileged to be here with you. As a young lawyer, I participated in the representation of Clarence Earl Gideon in the Supreme Court by assisting Abe Fortas, my senior partner, who was appointed to represent him. And I'm going to describe to you this afternoon the various problems that we confronted in representing Gideon and the way in which we resolved them. I'm also going to try to locate the Gideon decision in the general scheme of constitutional law, particularly in terms of the efforts of the Warren Court to reform the administration of criminal justice in the states by applying the various provisions of the Bill of Rights to the states. However, I'm not going to dwell only on the past. I want to address a point that was raised at nearly every symposium I attended during the year by one or more commentators who pointed out that the Gideon decision has not fulfilled the great expectations that we hoped for it, that it's been a disappointment in some respects. I want to discuss some of the factors as to why that is true. And I'm also going to offer some suggestions as to things we might do to fulfill the great expectations of the Gideon decision. In short, I'm going to talk about Gideon's past, its present, and its future. There were two architects of the Gideon decision. One of them was Abe Fortas, who was appointed by the court to represent Gideon and who wrote the brief on Gideon's behalf and made the oral argument in the Supreme Court on his behalf. The other architect was Justice Hugo Black, who wrote the opinion of the court. I'm going to discuss the issues and problems that confronted each of them and the contributions each of them made to the decision of the court. It is the practice of the Supreme Court, when it grants a petition of an informa pauperis petitioner like Gideon, who was, of course, an indigent defendant sitting in jail, it's the practice of the court to appoint a member of the Supreme Court bar to represent that petitioner in proceedings before the court. The court does not give any explanation as to why it appoints the particular lawyer, so we're forced to speculate on why the Supreme Court appointed Abe Fortas to represent Clarence Gideon. Fortas was a very close friend of Justice Douglas, dating back to their days together in the Yale Law School in the early 1930s when Douglas was a professor there and Fortas was a student. And Fortas knew a number of the other justices. I think it's fair to say that the Supreme Court regarded the Gideon case as an important case, and they wanted to appoint an eminent lawyer to represent Gideon. Fortas met that specification in every respect. Measured by any standard, Abe Fortas was one of the best lawyers of his generation. He was an exceptionally able advocate and lawyer. I think one other factor that may have influenced the court to appoint him was that he was widely known as a pro bono lawyer. He'd been involved in a variety of pro bono activities. A day or so after he was appointed as counsel by the Supreme Court in June of 1962, Fortas summoned me to his office, and he told me, I've been appointed by the Supreme Court to represent this petitioner. I want you to assist me in supervising the research and helping me to write the brief. And I had been privileged to work with Fortas on a number of matters for a decade prior to from the time I'd been an associate and coming to the law firm. And I recall very vividly his instructions. It's 50 years now, but I still recall vividly his instructions to me that morning. He said to me, I want to know everything about the right to counsel since the invention of money. And let me tell you, he meant every word of it. Not a day passed when he didn't call me and ask me for a memorandum on one other aspect of the right to counsel, on the right to counsel in the Soviet Union, on the historical right to counsel, and so forth. We were obliged, we had the responsibility as Gideon's counsel to present every argument that we could make in Gideon's behalf in order to secure the reversal of his conviction. But Fortas made clear to me from the outset, from day one, he made clear that he wanted to convince the Supreme Court in the Gideon case to decide that every accused person in this country who was too poor to hire a lawyer was entitled to have a lawyer appointed to assist him. There were two other persons who assisted me, joined me in assisting Abe Fortas. One of them was Ralph Temple, an associate in the firm, who later became the chairman of the American Civil Liberties Union office in Washington, D.C. The other person who assisted me came to the office as a summer law clerk. He was a third-year student at the Yale Law School that summer. His name was John Hart Ely. I asked Ely, shortly after he came, he was assigned to help me because of all the numerous requests I was getting from Fortas. I asked Ely to write a memorandum on something, and I didn't know what to expect. He gave it to me about a week later. And as soon as I read it, I knew at once that Ely was a person of an exceptionally gifted, able person, an outstanding person. And I was right. He later became a professor at the Yale Law School, professor at the Harvard Law School, the dean of the Stanford Law School, and the author of a book, Democracy and Distrust, which was one of the classics of constitutional law. Of the quartet who represented Gideon, I am the only survivor. I'm the last of the Mohicans, and that's the reason I'm here. Now, in order to assist you in understanding the problems that we confronted in the summer of 1962 in representing Gideon, I need to take a few moments to explain the status under the Constitution of the right to counsel as of 1962. And I need to explain what was the duty under the Constitution of courts, federal and state, to appoint lawyers to represent indigent defendants. There was a fundamental difference between the right to counsel in the federal courts and the right to counsel in the state courts. In the federal courts, it had been established in the mid-1930s that in every case, every criminal case, if the defendant was indigent and lacked counsel, the court was obliged to appoint a lawyer to assist him. If the court failed to do so, it lacked jurisdiction and the judgment was void. That was the situation in the federal courts. The situation in the state courts was altogether different. In the state courts, as of the time we were trying the Gideon case, it had been established that the courts were obliged to appoint a lawyer to represent a defendant in a case involving a death sentence, in a capital case. That principle dated back to the Scottsboro case, which has been discussed here this morning, Powell against Alabama, decided in the 1930s. But in every other case, that is in every non-capital case, in every other felony case, there was no duty on the part of the state courts under the Constitution to provide a lawyer to indigent defendants. This doctrine, that the state courts were not obliged to appoint defendants in non-capital cases, was confirmed in 1942 by the Supreme Court in a case which has been mentioned here this morning, Betts against Brady, which established that which held that in a felony case, a non-capital case, that the state courts were obliged to appoint a lawyer for an indigent defendant only if there were special circumstances in the case, such that a court could say, after the case was concluded, that this defendant was denied due process because he didn't have a lawyer. Now, it subsequently developed in subsequent cases that this special circumstances test covered such things as whether the defendant was mentally incompetent, or whether he was a juvenile, or whether the case was unusually complex. In such cases, there was a duty on the part of state courts to appoint a lawyer for an indigent defendant. But in all other cases, there was no such obligation. And that is to say, in all other felony cases that were non-capital cases, under the Constitution as of 1962, the state courts did not have a duty to appoint a lawyer for a defendant. Gideon was just such a case. In considering the arguments on behalf of Gideon, we had to deal basically with two problems. The first issue we confronted was how to deal with the precedent of Betts against Brady. This is an adverse precedent. When the Supreme Court granted certiorari in the Gideon case, it issued an order directing the lawyers for both parties to brief the question of whether Betts against Brady should be reconsidered by the court. And we had to respond to that directive by the court. Now, in order for us to prevail, we either had to distinguish Betts against Brady, to say that it was a different case, Gideon's was a different case, or we had to convince the Supreme Court that it should overrule Betts against Brady. Otherwise, we would lose. The second issue that we confronted was, was the question of federalism or states' rights. A decision by the Supreme Court that the state courts were obliged to provide a lawyer for indigent defendants in every non-felony case would have involved a major intervention by the Supreme Court in the administration of justice by the state courts. It would have required the states to appropriate money to provide lawyers for indigent defendants. Therefore, as you can see, there was a very significant issue of federalism or states' rights that was presented by the case. Now, I'm going to discuss each of these two issues, that is the Betts against Brady issue and the federalism issue, and tell you how we dealt with it and how the Supreme Court ultimately dealt with it. We carefully studied the record of Gideon's trial. Let me say it was very skimpy. And it was clear to us that Gideon was disadvantaged by the lack of an attorney to represent him. But there were no special circumstances in Gideon's case. It was a run-of-the-mill, plain vanilla case. Gideon was a 50-year-old man. He was not illiterate, he was not mentally incompetent, and let me say, he was not inexperienced in criminal matters. Now, neither Fortas nor I ever met Gideon. Let me say that would not be unusual in an appellate case as distinguished from a trial court. We were representing him on an appeal. But there is a lengthy letter from Gideon, which is reproduced in Anthony Lewis's great book on the case, Gideon's Trumpet, which sets out really Gideon's background, which I invite you to read. I should say sadly say that Tony Lewis, the author of Gideon's Trumpet, died just this spring in the midst of all of the events commemorating the Gideon case. And I would say his book is one of the best books about a Supreme Court case ever written. And it has inspired countless numbers of young people for 50 years to take up careers in the law and public service. Now, it was obvious to us as we began to deal with how we were going to write the brief in Gideon's behalf, it was obvious to us that this decision of Betts against Brady, which I have just mentioned, was on wobbly legs. In the first place, 4 of the Supreme Court justices, as of 1962, had indicated that they thought Betts against Brady should be overruled. Chief Justice Warren, Justice Douglas, Justice Black, Justice Brennan, in cases that come before the Supreme Court in the 2 years before Gideon, had indicated in concurring opinions that they thought Betts against Brady was wrongly decided and should be overruled. This special circumstances test was not a workable test. It was subjective. It invited endless litigation. Now, in the second place, the court's order granting certiorari in this case, in the Gideon case, was in itself an indication to us that at least 4 members of the Supreme Court, maybe more, felt that the question of the right to counsel for an indigent defendant in state courts in non-capital cases presented a serious and substantial question. Otherwise, the court wouldn't have agreed to review it. So we knew right away that the court deemed this presenting a serious and substantial question of constitutional law. And finally, the court's specific request that we discuss whether Betts against Brady should be reconsidered was an unmistakable signal to us that the court was seriously, at least some members of the court were seriously contemplating overruling Betts against Brady. Now, but we had to furnish the court with arguments that would justify their doing that. In our brief, in the brief we wrote, we attacked Betts against Brady head on. That is, we challenged the fundamental premise of Betts against Brady, which was that you could have a fair trial without a lawyer. We said that was not the case. Our argument was that in every case, every criminal case, an accused person must have the assistance of counsel pursuant to the Due Process Clause to have a fair trial. We stress that a layman simply cannot understand the nature of an indictment or the charges against him. He cannot understand whether a search and seizure is reasonable or not. He doesn't know whether a confession is permissible or not. He does not know how to deal with various questions of evidence. He's not versed in how to make an opening or closing argument. As Justice Douglas observed in one of his concurring opinions, a defendant in a criminal case confronts a labyrinth which he neither understands nor how to navigate. We next argued that there was no legitimate basis for the distinction that had been made between capital and non-capital cases as to the constitutional duty to provide a lawyer in the state courts. It was irrational. In many non-capital cases, there was even greater need than a capital case because the issues were far more complex. Now, we then turned to the central issue which we felt was presented by the case, namely federalism. In the 1960s, you have to take a moment to give you a little bit of constitutional history here. In the 1960s, at the time we were writing the Gideon brief, the justices of the Supreme Court were deeply divided over the question of the extent to which the Bill of Rights, the first 10 amendments, applied to the states. As you know, the Supreme Court had decided, those are particularly law students will know this, the Supreme Court decided in Barrett against Baltimore in the 1830s that the Bill of Rights applied only to the national government and did not apply to the states. And that was the situation, still was the situation as of 1962. Now, the issue presented in the Gideon case was whether or not the provision in the Sixth Amendment should apply to him by reason of the Due Process Clause of the 14th Amendment, which applies to the states. Justice Black had written an opinion for the court in 1948 in a case called, a dissenting opinion in 1948 in Adamson against California, where he maintained that all of the Bill of Rights, every provision of the Bill of Rights, was made applicable to the states pursuant to the 14th Amendment. But Justice Black stood alone in that position. The other members of the court did not agree with him. And as of 1962, the court had applied only a couple of the provisions of the Bill of Rights to the states. The other provisions had not been applied to the states. Viewed in one way, the question presented by the Gideon case was whether or not the right to counsel protected by the Sixth Amendment, which says in every criminal case, the accused shall have the assistance of counsel, did that apply to the states pursuant to the 14th Amendment, which provides that the state may not deny an individual due process. Now, we didn't want to get caught up in a crossfire among the justices as to whether or not the Sixth Amendment was incorporated in the 14th Amendment. We knew that some justices would say yes to that. We were aware that other justices would say no to that. And we wanted to avoid being, as I say, caught up in that crossfire. So we made the argument that Gideon was entitled to the assistance of counsel. Indigent persons were entitled to assistance of counsel based on the Due Process Clause standing on its own bottom, that is considered independently of the Sixth Amendment. That was our argument, that a fair trial protected by due process required that in every case, criminal case, a defendant should have the assistance of counsel. Let me say, we were supported, in this connection, we really made 2 points. Let me explain what we argued. In the first point, we said, the first argument we made was this to the Supreme Court. We said, look, if you decide that Gideon and all defendant criminal accused persons are entitled to a lawyer in non-capital cases, you're not going to be making a major change in state practice by doing this. This isn't going to be a radical innovation that you have to be concerned about. As of 1963, at the time the Gideon case was argued, in 45 states required that a lawyer be appointed in every felony case, capital and non-capital. That was the practice. Not pursuant to the federal Constitution, but pursuant to state Supreme Court rulings, state court decisions, state court rules. There were 5 outlier states which did not so provide. They provided that you had to have a lawyer in a capital case. So we said to the Supreme Court, look, this isn't going to be a dramatic revolutionary change. You're really going to just be filling a gap by requiring that the state courts provide counsel now in all cases. We were supported in our position by an amicus brief, which was filed by 22 state attorney generals, who said that that was correct, that a lawyer should be appointed in every case. Now, there was one other argument with respect to states' rights that we made. Fortas had the brilliant insight, really, that the special circumstances rule what imposed was a greater intrusion on states' rights than was the rule which we proposed. Look what the situation was. In every case tried in a state court where a defendant lacked a lawyer, subsequently a petition for habeas corpus would be filed in a federal court, asking the federal district judge to review the state court proceedings on the basis that the state courts had denied the accused person a lawyer. That was the argument that was being made over and over again in the federal courts. And Fortas's insight was that, look, this is a tremendous intrusion on states' rights by this process, because what you have is a process whereby state court judgments are being reviewed by the federal judges. How? On an ad hoc basis, case by case. And how else? Ex post facto, that is, looking at the case after it's over. So he said that's a tremendous intrusion on state rights, whereas the rule we're suggesting, you won't have that kind of thing going on. And we pointed out that the states would be free to devise the methods by which the counsel would be provided, so there would be less of an intrusion on state rights. Now, Fortas's superb oral argument was recorded, and you can listen to it. In his autobiography, which was written around 1980, Justice Douglas says in his autobiography, and I want to quote, he said, "In my time on the Supreme Court," and he'd been on the Supreme Court for 34 years at the time, he says, "probably the best single argument was made by Abe Fortas in Gideon against Wainwright." Now, that's very high praise indeed, and even making due allowance for the fact that Justice Douglas and Abe Fortas were very close friends. Now, following the oral argument in January of 1963 at the conference of the court, Chief Justice Warren assigned the writing of the opinion in Gideon against Wainwright to Justice Hugo Black. That was a most appropriate designation. Justice Black had written the opinion of the court, the Supreme Court, in 1938 in Johnson against Serbst, which ruled that the federal courts were obliged to provide a lawyer for indigent defendants in every case. Justice Black had written the dissent in 1942 in Betts against Brady. He dissented at that time. And he had made clear earlier, before Gideon was decided, that he felt Betts against Brady was overruled. So it was appropriate that he be asked to write the opinion of the court. Now, the Justice Black, let me say, in considering the problems that he confronted, that Justice Black confronted, he had to deal basically with two questions. First, he had to deal with the question of Betts against Brady. After all, that was the leading precedent, and you're writing the opinion, you're going to have to face up to it. He either had to say, this case is different, Gideon's different from Betts Brady, so we can distinguish it, or you're going to have to say, we are going to overrule Betts against Brady. Now, Black's view, supported by a majority of the justices, was that Betts against Brady should be overruled, that it was erroneous. He thought that in Betts the courts had taken a wrong step. And as he put it, reason and reflection require us to recognize that in our adversary system of criminal justice, any person hauled into court who is too poor to have a lawyer cannot be assured a fair trial without one. So what he did, he said, he wrote speaking for the majority, he said, we believe Betts against Brady was erroneous and it should be overruled. Now, Justice Black then had to deal with another issue that we had finessed in our brief. We said, as I mentioned earlier, we said that the right to counsel should be based just on the due process clause standing alone, the due process clause 14th alone standing alone. But Justice Black dealt with the issue in a different way. He made clear in his opinion that the court was guided by the fact that the right to counsel was protected by the Sixth Amendment against the national government. As he pointed out, that indicated this is a fundamental right. And fundamental rights protected by the Bill of Rights, Justice Black said, against the national government must also be protected against the states, infringement by the states. And therefore, he incorporated, in effect, the Sixth Amendment right to counsel into the 14th Amendment and made a right previously applicable only to the national government. He made it applicable to the states. Now, Justice Black's opinion in Gideon is typical of many opinions that he wrote. It's short, it's very brief, it's free of legal jargon, it's intelligible to a layman. There were two main themes in Gideon's opinion, and in Black's opinion, Justice Black's opinion in Gideon against Wainwright. First of all, his opinion reflects the position, the view of the Supreme Court, that in our adversary system of justice, no person can be given a fair trial without the assistance of counsel. A court is not properly constituted unless it includes a defense attorney, an attorney for the defendant. And Black's opinion reflected his own personal experience. You must remember that Black had been a police court judge, a trial court lawyer, and a prosecutor in the early years of the 20th century in Birmingham, Alabama, a very tough and violent steel town. So he knew from personal experience how important it was to have a lawyer at your side. Secondly, this opinion by Black and Gideon reflects Justice Black's profound empathy, his understanding, his sympathy, if I can use that word, empathy, for persons who were poor and disadvantaged. It was absolutely unacceptable, just unacceptable to Justice Black that a person should be denied a fair trial because he was too poor. As he put it in his opinion, a lawyer is not a luxury, it's a necessity. In the biography of Justice Black, Roger Newman, who wrote a biography of Justice Black, describes the scene in the Supreme Court on the morning of March 18th, 1963, when the opinion was announced. And let me just quote briefly as to how he describes the scene when the opinion was announced. He said, when Chief Justice Warren turned and called on Justice Black to deliver the opinion, Justice Black leaned forward, and he spoke in an almost folksy way, reading sections of his Gideon opinion. Happiness, contentment, gratification filled his voice. When Betts against Brady was decided, he said a couple of weeks later, I never thought to live to see it overruled. The Gideon decision, this is what Newman described, it was indeed a moment of supreme satisfaction, one of the highlights of Justice Black's career on the Supreme Court. Let me say, just to add my own views, of all the justices who sat on the Supreme Court in the past half century, I regard Justice Black as the foremost of all the justices. As a matter of constitutional law, the Gideon decision was important for several respects. In the first place, it filled a gap in constitutional law with respect to the right to counsel in the state courts, which you recall applied only in capital cases. After Gideon, we could say that in every case tried in both the federal and state courts, every criminal case, if a defendant is too poor to have the assistance of a lawyer, a court has the duty to appoint a lawyer to assist him. Now, the Gideon decision was also important for another reason, for another very fundamental reason as a matter of constitutional law. One of the major efforts of the Warren Court was to reform the administration of criminal justice in the state courts in order to protect poor persons and black persons. And they wanted to do that by making the various provisions, the various procedural rights of the Bill of Rights applicable to the state courts, which had not been the case, as I said prior to that. The Warren Court proposed to make this reform by extending the various provisions of the Bill of Rights to the state courts. And the Gideon case was a critical step, a critical link in that process. After the Gideon case was decided, which says that the Sixth Amendment right to counsel applies to the states by the Due Process Clause, in a series of cases decided after the Gideon case, the Supreme Court decided that various provisions of the Bill of Rights did apply to the states, such as the privilege against self-incrimination, the prohibition against double jeopardy, and so that the Gideon case, in a sense, broke open. It broke open the floodgates to making the Bill of Rights applicable to the states, and so as that process continued just until 3 years ago, when the Supreme Court decided in a case, most of you probably are familiar with, McDonald against City of Chicago, that the right to bear arms in the Second Amendment, which is protected against federal infringement, applies to the states, also pursuant to the Due Process Clause. So that nearly all the provisions of the Bill of Rights, nearly all of them, with a few exceptions, are now applicable to the states. And the Gideon case, the Gideon decision, I say to you, was a very significant building block in that tremendously important process. Now, there were several aspects of the right to counsel that we did not address in our brief. That became things that were evident afterwards. It is not sufficient for a defendant to have any lawyer to represent him in a criminal case. He needs a lawyer who is competent to try a criminal case. And that lawyer also must have the financial resources to investigate the matter, to hire experts to assist him. We also, let me say, we did not deal with the very important issue of collateral consequences which can result from a criminal conviction, an issue which was addressed by panelists earlier today. That was not an issue on the table in the Gideon case. We also, let me say, we did not address the right to counsel which exists in plea bargaining situations. That issue was not so evident in 1963 as it is today. And also, we did not turn and consider the question of the right to counsel in civil actions, where there may be rights of very great importance at stake. What we wanted to establish was this fundamental principle that in every criminal case in this country, every case, a defendant who is too poor to hire a lawyer must have the assistance of counsel. Now, recently, that is during the past year, in programs commemorating the 50th anniversary of Gideon, invariably, one or more commentators has said, look, the great hopes and expectations we have from the Gideon case have not been fulfilled. It's been a disappointment. And regrettably, I have to say that is true. The Gideon case did greatly inspire the public defender movement. It greatly encouraged that. There's no question it did that. There's also no doubt that it considerably improved the representation of defendants in criminal cases. But it is undeniable, it is absolutely incontrovertible that many defendants facing criminal charge in this country today are not adequately or competently represented. That seems to me absolutely beyond dispute. Now, let me say this same observation about hopes not fully realized, hopes not fulfilled, certainly could be made about another great Supreme Court case, Brown against Board of Education. The great hopes surrounding that case also, let me say, have not been fulfilled in a variety of ways. But the fact that the high hopes have not been fulfilled does not diminish the luster or the great importance of the Brown case or the Gideon case. To the contrary, it's a wake-up call in the night that we have unfinished business, that we have important rights that need to be more fully implemented and that we should implement. Now, let me say the question remains, why has the decision in Gideon not been more fully implemented? That is to say, why is it the case that many defendants are still not competently or adequately represented? Now, I believe there are a number of reasons, some of which have been talked about by some of the panelists today and will be, I'm sure, addressed more fully during the rest of the discussions during the rest of the day. Number one, there have been very significant changes in the criminal law since 1963. A number of activities which were not criminal then have been criminalized. That is particularly true in the areas relating to drug offenses. And one of the factors, a result of that, is that, put it this way, that that the number of criminal cases is overwhelming the availability of defense counsel. So that has been a very profound, significant change. In a book written last year, came out about a year ago, called American Justice, the Collapse of American Justice, written by a professor at Harvard, William J. Stuntz, who regrettably, an eminent professor who died before his book was published. He deals in his book, addresses the tremendous rates of incarceration which has developed in the United States. He points out that the level of imprisonment in our country, in the United States, exceeds the level of imprisonment, the rate of imprisonment in the Soviet Union under Stalin. Think of that. And over 2.25 million persons in the United States are now behind bars. The level of imprisonment of young black men has reached astronomical levels. The fact is that the black imprisonment rate is now 6 times the rate of imprisonment of white persons. And it's now estimated that if the present rate continues, 1/3 of all black men, 1/3 of all black men who lack a college education will spend some time in jail. I submit to you that is a morally unacceptable situation. Now, another factor which explains why the Gideon case has not been more fully implemented is this. The Gideon decision contemplated that the state legislatures would appropriate money to pay for defense counsel. But the decision did not provide any mechanism or procedure for implementing that particular requirement. It did not specify any level of the amount of money which state courts should appropriate, which state legislatures should appropriate. That was a big gap in the decision. And let me say that the demands for counsel, the financial demands for counsel for indigent defendants has a very low priority in many state legislatures. Now, a third thing that's happened is that another factor that has affected the Gideon decision is that in a case subsequent to Gideon, in a case called Strickland, the Supreme Court really greatly undermined the principle that the lawyer represented must be effective. The court said there's a presumption of competence and that the defendant must show that the outcome of the case would have been different if he'd had a competent counsel. They've imposed a very high standard to demonstrate that counsel is ineffective. As a result of that decision, there have been many cases in which accused persons are represented by lawyers who are incompetent, who slept through trials, who are on drugs, who are just totally incompetent, and yet the courts have upheld the competency, have upheld the effectiveness of counsel. There's finally one other factor which has affected why Gideon is not more implemented. Subsequent to Gideon, a number of rules have been evolved in the federal courts involving procedural rules regarding the availability of habeas corpus in the federal courts, with the result that it's very difficult for a prisoner in a state court who is not adequately represented to secure review of his conviction in the federal courts. Now, in my opinion, there's a basic underlying factor. There's a political reason why Gideon has not been more effectively implemented. I submit to you that there has not been an effective political constituency for the right to counsel for indigent person. Ask yourself this question. Who are the persons most seriously affected by the absence of counsel? They are primarily persons who are from minority groups. They are poor. They lack education, or they are very limited education. They lack financial clout. And the fact that there is no political clout is one of the main reasons, one of the main factors why representation of defendants has received so limited attention from so many state legislatures. You have to bear this in mind, that approximately 80% of the persons charged with crime are poor, and 70% of the persons who are in prison lack a high school education. So the absence of an effective political constituency is an important factor. Now, if the Gideon decision if we're to realize the great hopes of the Gideon decision, I think there are a number of things that have to take place. First of all, there are a number, by Congress, by the state legislatures, by federal and state courts, and by those of us who are members of the bar. First of all, with respect to Congress, a number of things that are criminal, now criminal, particularly in the area of drugs, should be decriminalized. The announcement recently by Attorney General Eric Holder that federal prosecutors are no longer going to prosecute low-level drug offenses, which are nonviolent, to the criminal process is a step in the right direction. Those persons should be treated outside the criminal law process. And other things which are criminalized, a number of other activities, we have over-criminalized things, and both the federal and state legislatures need to deal with that question. That's number one. Number two, a public defender system should be established in every state. That system should be adequately financed. That people in it should be adequately, effectively trained. There should be a public defender system parallel to the state prosecutor system. And the state, both the federal and the state courts have a duty to insist. They should insist that defendants must be adequately and competently represented if the due process clause is to be protected. In the third place, the standards governing competent adequacy of counsel, the Strickland decision should be re-examined, and the court should be more realistic about what constitutes adequate and effective counsel. The present standard is totally unsatisfactory, and it should be greatly strengthened. Fourth, and finally, this. I would say that if Gideon is to be implemented, members of bar associations, private law firms, law schools, we have to unite together with other groups and organizations who believe that our Constitution requires that every poor person should have an assistance of a lawyer. That is what our country stands for and believes in. And I believe if those various steps were taken, if we were here at the 100th anniversary, perhaps we could say the high hopes of Gideon have finally been implemented and realized. Thank you very much.